We're going to start off with the latest in regards to the Janel Grant case, because over the past couple of days, we have got lots of filings. And Brandon, you have devoured a lot of these documents. We have got filings from Vince McMahon's legal representation. We also got WWE's response to the case. And we now have a firm alignment of the defendants that are very clearly all aiming for the same forum for this case to be tried, and that is in arbitration.
Yes, we got the first filing really from WWE, which was last night, in fact. Because yesterday was the deadline for WWE to respond, and 4:00 went by, and usually that's when you get legal filings. They like to, put the ratings out in the legal filings at the same time to mess with me. But we did get a filing for the first time from WWE's lawyers, from Paul Weiss. And we got a preview of it in a briefing schedule that was put out before, saying they expect to also move to compel, and they moved to compel to arbitration, and they did. So everybody, as John Laurinaitis has maybe was going to side with Grant, but then turns out not. So all three defendants, WWE is being sued in this case, as well as Vince McMahon and John Laurinaitis, they're all moving to arbitration, which means if the judge decides that this should go to arbitration, then that would be handled in private and would not be in the public court where everyone can see it. So that's what the judge eventually, I'm not sure how the timeline will play out. You never know in these legal issues, but that's what the judge will have to decide, whether this should go to arbitration or whether this should continue as a public lawsuit.
My scholarly analysis of the timeline, slow. That's how I predict this is going to go. Very slow. As we continue to debate where this arena will where this will be occupied. But so let's go backward. And the attorneys for Vince McMahon, they filed a memorandum on Monday opposing Janel Grant's motion to strike previous statements by McMahon. So we go back a couple of weeks ago, Vince McMahon responded to the suit, and this was the outline trying to discredit Janel Grant. This was using the examples of when her parents had passed away, whether she was in fact a full-time caregiver, and then Ann Callis had a pretty swift response to that as well. And then the Janel Grant side, they wanted that stricken from the record. And essentially in this memorandum, Vince McMahon's team is stating that they were privy to, or the public was privy to, the 67-page lawsuit. They have a right to defend themselves, and and they're calling it meritless and the height of hypocrisy for Janel Grant's side to want this stricken from the record when it is Vince McMahon defending himself and trying to discredit Janel.
Right. So this is sort of responses on top of responses here. But as you said, when Vince put out his preliminary statement, which was in addition to the legal argument, the sort of more boring legal argument about why this should go to arbitration, he also put out this preliminary statement citing legal cases and saying that, her parents had actually died a couple of years before she even met Vince, and suggesting that she's exaggerating this notion that she was still grieving for her parents. So that happened. And then when that happened, Ann Callis who is Grant's lawyer, filed this motion to strike. So what they're saying is that, this is relevant to the case. And, you can't strike this because it is relevant. This is showing, why you shouldn't believe Janel Grant's allegations, and this should not be stricken from the record. So that's their argument.
Yeah. Another issue they brought up was that Janel Grant was still living with her fiance, which Janel Grant's side came back, stated this individual, Brian Gonzalez, was no longer her fiance, but that the plaintiff was living in a luxury multi-million-dollar building with another man during her entire relationship with the defendant. It is relevant context to the validity and enforceability of the arbitration provision, which the defendant bears the initial burden of showing. There is no basis to strike either the entire preliminary statement or any sentence within it simply because the plaintiff doesn't want those facts known to the public. So that was essentially their argument, that these are all relevant facts. She can quibble about whether this person was her fiance or not. They don't feel it's enough of a significant mischaracterization to have it stricken from the record. And it all goes back to the agreement that was signed in January of 2022 that McMahon's side is vociferously arguing to the letter of the agreement that any dispute should be done in arbitration, and this is cut and dry. This should not be up for debate. And adding the fact that in terms of the text messages that we saw Vince McMahon's side of the conversations released in the January lawsuit, now we have Vince McMahon's side stating that while the defendant is no longer in possession of the text messages between the parties, as Vince McMahon had deleted them when he broke off the relationship, the discovery in this case will show that the plaintiff sent him sexually explicit images of herself and texted him and listed a bunch of accusations here in terms of what was contained in the text messaging, indicating the fact that this was very consensual and that Janel Grant's inferring that her texts were as damaging, if not more so, and would paint a more clear picture of this relationship if they were to be released. But Vince McMahon doesn't have these texts, so we're going off of Vince McMahon's memory and what he has relayed to his legal team, and they are implying that Janel Grant still has the full conversations of these text messages, which you could make that assumption based on the fact they were released in the lawsuit. But does she have these text messages? Has she deleted any text messages? That would be a question for the plaintiff side.
Well, and they're talking about this being released in discovery. Maybe the mobile carriers would have this if they subpoenaed. I don't know. It sounds like maybe you can subpoena, say, Verizon or something like that, or AT&T or whoever their carriers are, and maybe they would have records of these that could be obtained in discovery. But you know what they're pointing out here is that so McMahon's side is saying, hey, there are other sides to these text messages that she didn't show, and I guess that's supposed to support the notion that this was a more consensual relationship than Grant is saying it is. McMahon's side is pointing out that she fantasized about being held down, about being in pain, about wanting rough sex and things like that. Contrast that with Grant's allegations are that she was raped, that she was sexually assaulted by both McMahon and Laurinaitis in WWE headquarters in one scene, and that this was a very controlling relationship. Can both of those things exist at the same time? Can you have a very aggressive style sexual relationship, but then also be assaulted? Logically, yes, both of those things can exist at the same time.
Yes, I think that is, look, how would you look at this in terms of McMahon's defense at this point? Because now we have several instances of their attempt to level the playing field when it comes to public perception, going back to the New York Post release of the quote unquote love letter. We saw a pretty, I won't say glowing piece, but on Vince McMahon, but in terms of him, rescuing dogs and such. I mean, we've seen all these different examples. And then of course his statement coming back here, I get the sense, I don't know if you are going to be able to tip the public's opinion towards Vince McMahon, but that is the objective. Do you feel that they are at all succeeding in that front of getting Vince McMahon's side across, and that there is any kind of rethinking when it comes to people's view of Vince McMahon? Or is it just these allegations are so heinous and we have not seen any kind of smoking gun at this point to exonerate Vince McMahon?
I haven't sensed that. We still have, the Grant complaint was really a turning point, right? He resigned and there were these graphic descriptions of assault and a controlling non-consensual relationship. That's her side of the story. And W has distanced themselves, apparently, from Vince McMahon. We saw that. That was one of the big takeaways. Not only was the story finished by Cody Rhodes, but one of the big takeaways was that this was a new era, and that seems to be code for this is the Vince McMahon free era. And that's sort of the impression I think that the wrestling fans at least have. Add that into, there are 7 different women with allegations of sexual misconduct against Vince. 4 of them had NDAs that had to be disclosed and that WWE had to make financial changes to their financial reports because of. And then there's also the Rita Chatterton allegation of rape that also has NDAs associated with it. There's 2 women at separate spas that allege sexual misconduct by Vince McMahon. So there's an apparent track record of this sort of behavior from McMahon that I think is going to be difficult to make the public forget about, or to make them believe that it's that these allegations aren't true.
And we are largely talking at this point about the wrestling audience that I would state that is following this and keeping up on the latest filings and such, because we've seen such a drop off even from, some mainstream outlets that were covering this, that largely it feels that unless this were to go to trial, I don't know how much re-engagement you're going to see from a higher profile level of some of the outlets that had been looking at this story, that it seems as though this is pretty in the weeds for a lot of people to be following the minutia of all of these statements and such. And I think anything short of a trial, I don't know how much attention it's going to get beyond whatever the conclusion of this is.
And if this goes to arbitration, it gets pretty quiet at that point, unless there's some way that those parties could make the details of arbitration public, which is not clear to me.
So just continuing on, this again is still from Vince McMahon and his legal team. Their filing on Monday was the fact that we also got on, let's go fast forward to Tuesday, where McMahon filed a statement of undisputed material facts supporting his motion to compel arbitration, and just reiterating the negotiated terms. Of course, it was Jerry McDivitt negotiating on behalf of Vince McMahon from K&L Gates, and Jonathan M. Shapiro, who was the former lawyer for Janel Grant from the Ayton Law Partners LLP. And it stated in this statement that Grant was initially offered $1 million, and she was able to negotiate up to $3 million for the NDA, with $1 million paid within 10 days of the execution of the agreement in January 2022. And then every February 1st for the next 4 years, she would receive installments of $500,000. The first installment period in 2023, McMahon did not pay because this came months after the Wall Street Journal reports and felt that the NDA had been violated. And that's how we get to this present arrangement between them. And a lot of this is just going over like the language in the NDA, which is just outlining any dispute arising under or out of this agreement, its construction, interpretation, application, performance, or breach. The parties agree to first attempt to resolve such disputes informally and prior to taking any formal legal action to resolve such disputes. And in the event that any such dispute cannot be resolved informally, all parties hereto agree that the sole and exclusive legal method to resolve any and all disputes and or controversies is to commence binding arbitration under the Federal Arbitration Act, pursuant to the procedures of the American Arbitration Association, which we'll just call AAA from now on.
Yeah, not one of our favorite acts among federal legislation. So I guess one way to think about this is that there's this NDA agreement, and I think when we say, well, that's kind of like ATM machine, right? That there's this NDA, and when we say there's this NDA, we're thinking like that they only agreed to non-disclosure, and it was like in exchange for money. But I guess what a contract is it's this series of clauses and agreements. It's sort of this bundle of agreements. One of the things that they agreed to, which was very important in this case, was that they agreed to not disclose anything about their relationship, right? And they agreed that Vince would pay her money over time. But what's also, what the defendants are especially pointing out here, right? What's also a part of this agreement is that there was an arbitration clause, so that any dispute, any disagreement that we have over this agreement should go to arbitration. And that's what the defendants are all emphasizing at this point. What Grant's side is arguing is that, well, because for various reasons, because she reported that, or because she was coerced into this agreement, she says, because of the Speak Out Act and other reasons, this agreement shouldn't be enforceable. And it's also important to remember that the Speak Out Act is a new piece of legislation, and the language seems pretty unclear to me. There's language about pre-dispute and before the dispute. So it seems like classically the Speak Out Act is supposed to be about when you come into a job and they make you sign an NDA right away, and then you're the victim of misconduct, that NDA should not be valid. This is a case of an NDA being made after alleged misconduct happened. Although importantly, I think that we'll see what happens as far as Grant's future filings here. I think it's very important to point out that she raises that she was assaulted again by McMahon after the NDA was signed. So that could become an important issue, which she has not raised, and nobody's talked to us about that. But I sort of feel like that's an important issue. We'll see if that comes up. And I think there's another thing that maybe people aren't clear about is that it seems pretty clear to me that Grant disclosing to the friend who supposedly writes the anonymous email to the board, that's how the NDA is initially broken. That's how the agreement is initially broken, right? He misses the first payment almost 1 year after that point. And that's why he stops paying. Apparently, he feels like she broke the NDA by disclosing it to the friend, and there's an anonymous email. The board finds out, so he's not going to pay this anymore. It wasn't a matter of Vince just deciding to stop paying.
It's also brought up the exact date that they reach out to Janel Grant's legal counsel. It's March 30th of 2022. So it might be even to the day that the board gets this anonymous email, and they're immediately going to Janel Grant, believing that she has now broken this confidentiality.
And I guess we should entertain, like, is there any way somebody could have known about that relationship without knowing about it from Janel Grant? I don't know if that's something that they would try to argue. The person, we've never seen the email itself, but the person, according to the Wall Street Journal reports, asserts to be a friend of Grant. So, I mean, how else would that person have known about it?
Yeah, it's a relevant question. If there was any room there for other people to have knowledge of what's alleged to have occurred here. So that is kind of the Vince McMahon side. And then what we were waiting for was WWE filing its motion, which happened on Tuesday night, just hours after this latest filing from Vince McMahon. And WWE is disputing Janel Grant's allegations, but as a threshold matter, this dispute cannot be heard in court because Grant agreed to arbitrate her claims. WWE therefore moves to compel this action to arbitration. Simply put, Grant has no claims actionable in this court because the separation and non-disclosure agreement she signed with McMahon and WWE, the monetary benefits of which she concededly accepted and retained, contains an arbitration provision that unambiguously precludes this court from adjudicating her claims. In particular, Grant agreed that the sole and exclusive legal method to resolve any and all disputes and or controversies is to commence binding arbitration under the Federal Arbitration Act. The language is clear and unconditional. Not only are Grant's allegations squarely within the scope of the arbitration provision, but the agreement also expressly commits to arbitration the issue of arbitrability itself. Add that one to your Google search. Accordingly, this court should enforce the parties' agreed upon method of addressing Grant's claims and compel this action to arbitration. So in a nutshell, they are in lockstep now with Vince McMahon and John Laurinaitis pushing for this to go to arbitration. And you would have to do a bit of assuming here that WWE is, I feel, publicly wants to distance itself from Vince McMahon, but as a matter here, I think it benefits them greatly that this is not some public trial, that their letters are going to be splashed over all of the headlines in connection to this. And if Vince McMahon is successful in discrediting Janel Grant and making this go away, well, WWE is also that further removed from this case.
Yeah, I think it's interesting. What do you think about this? They use this word concededly twice, or at least some form of it, the monetary benefits of which she concededly accepted and retained. Basically, what they're saying there, it's not clear, is that she took the first $1 million payment, and is WWE calling her conceded? Is it kind of they are denying the allegations, but they haven't really attacked her, and this is the closest to some sort of verbal attack by WWE. I think it's slight, but it is saying that, like, well, why would you take the money and keep the money if if you had all these issues with the NDA?
You could read it that way. You could certainly infer the fact that,
or is it if there was in the sense that, like, she's giving into the agreement and cooperating with the agreement by keeping the money.
Well, I would, again, we're trying to get into their head here, the meaning behind it, but you could certainly interpret it as if this was such a significant issue, that was the time to raise it. And I mean, it's a greater discussion about just the pressure that she would have been under in this particular situation. But I think that is going to be the strategy here of looking at, you accepted this money and you violated the agreement. You entered this agreement willingly, and that's probably going to be argued too by Janel Grant's side of how willingly she was to enter this agreement in the case of who she was up against and what was presented to her.
Yeah. And I guess as far as a legal argument, I'm getting the sense that it's going to be difficult for Grant's side to avoid arbitration, at least partially here. And partially is an important thing that's raised too. That's sort of a new subtle layer to this legal argument that WWE in this case is raising, that, hey, look, even if some of these things shouldn't go to arbitration, the judge should still allow the arbitrator to decide that. And if some of this should be handled in public court, maybe, but that's not for the court to decide. That's for the arbitrator to decide. And then the question for Grant's side, I think, is, do any of these arguments that they've raised about why this NDA should not be enforceable, do any of those disqualify the arbitration clause? The Speak Out Act pertains to NDAs. The Speak Out Act doesn't say anything about arbitration. So we'll see if any of that how any of that is argued by Grant's side when they do put in a reply.
The Grant side, since these filings, has been relatively quiet. We did get a comment from Ann Callis that simply said, for any comment, see our original filing. We're confident the truth is laid out well there. So it does seem as though Grant's side is not looking to engage in any public back and forth here, but it was essentially the Vince McMahon and WWE sides getting out their latest statements this past week. And again, going back several weeks to where John Laurinaitis essentially flipped and aligned with Vince McMahon as well. So that's where we stand now. And it remains sort of on this timeline of where we go forward and the ultimate ruling of if this will be done in arbitration. And larger questions that hang over this are, what is Vince McMahon's goal here? Is it simply to hold her to this non-disparagement agreement or non-disclosure agreement and have this done in arbitration? Because his reputation has been absolutely tarnished in what this lawsuit has outlined regarding him. And you would have to think that Vince McMahon is looking to repair his image to get back into whatever it is he wants to do with his remaining working years. We've questioned, is arbitration really the best forum for that? And what are the restrictions about a ruling in arbitration where, in theory, both sides would be kind of held to a agreement that they would not be able to disclose the findings? Is that going to be enough for people to have a confidence in working with Vince McMahon?
Working with him in what? Does he have future business plans? He's got lots of money for sure. He has liquidated more than $1 billion in TKO stock. He's still, as far as we know, holding 8 million shares. So plenty of money at his disposal, unless he's already spent it to do whatever he wants. Retired to the yacht.
So we will continue to follow the ever expanding court docket when it comes to the Janel Grant case.
And just add one more thing. I was discussing this with Todd Martin in terms of the language around the Speak Out Act, and with it being such a new piece of legislation that was only put into effect in December 2022. And with the sort of vague language, as I talked about on the Sunday podcast for subscribers, it does seem like that there may have been some back and forth in terms of how that act was, how its language was written. Because they, in a previous version of the Speak Out Act, there was a specific definition about what a pre-dispute NDA was, where it clearly defined a pre-dispute NDA as any NDA that any NDA after which a lawsuit occurred. So basically, it would totally apply to Grant's NDA. There's a lawsuit that happened. And then well before that, there was an NDA, but then it was changed and the language was made more ambiguous. That definition was taken out of it. I mean, like, long story short, I doubt this case is going to go away absolutely for a long time. And there could be appeals. And I don't think it's even unreasonable to imagine that this issue might eventually be taken to the Supreme Court. But, who knows?
And we feel like broken records, but let's also remember the fact that a federal indictment is not out of the question. And then this becomes a whole different ballgame in terms of what this could grow into and and takes this from a civil matter into a criminal one, if there, well, we know of the existence of a federal investigation, but if an indictment is to follow, then suddenly there will be a lot of renewed focus on this story from a lot larger of a media spotlight.
Yeah, and whatever news follows out of that, I mean, who knows the details that might be uncovered through a criminal investigation, as far as we know, is still ongoing, related to the Southern District of New York, which is sort of the federal district that has probably a lot of resources and has the ability to thoroughly investigate a big story like this would be.